brand Louis Vuitton is celebrating the 130th anniversary of its classic monogram pattern, but a trademark dispute has recently emerged.
The brand has sued Molly T, claiming that their trademark is highly similar to the floral pattern used in LV's own product.
The trademark protection has an exception to the rule called dilution, and a milk tea company just found out the hard way, and it cost them $1.5 million US. The ownership attorney has entered the chat. In May 2025, Louis Vuitton filed a trademark infringement lawsuit against Molly Tea, a fresh milk tea chain founded in 2021 in China that has grown to more than 2,000 stores. Molly Tea's 4-part flower emblem infringed the 4-petal flower marks inside Louis Vuitton's registered monogram pattern. And on June 29, 2026, the Suzhou Intermediate People Court agreed. It ruled that Molly Tea infringed 7 of Louis Vuitton registered trademarks and ordered the company to pay economic losses plus legal costs, with a franchise store jointly liable. Molly Tea had tried to register this logo, and in 2024, most of those applications were rejected, but the company kept using the design anyway. So here are 3 lessons that you can learn from this case that matters legally. Lesson number 1, the tea company logo was not an exact copy of the Louis Vuitton monogram, but for a dilution claim, it does not have to be. For figurative marks, protection does not require the infringing mark to be identical to the registered mark. The question is whether an infringing trademark creates a connection that causes damage to the trademark owner. The court found that the resemblance was close enough to create this connection. So before you build a brand around a design, get a real trademark clearance opinion. The trademark proceeding is a legal process where clearance searches should not be overlooked and rejections cannot be ignored. Lesson number 2. Famous marks do receive a second layer of protection internationally. So dilution protection is covered in the US under federal trademark law. Additionally, under international trademark law, dilution claims are addressed primarily through treaties that extend protections to well-known marks. This is known as the Agreement on Trade-Related Aspects of Intellectual Property Rights, also known as the TRIPS Agreement. And determining whether a mark qualifies as a well-known mark and triggers these protections, member nations must take into account the public's knowledge and familiarity with the trademark in the relevant sector, including knowledge obtained within that member's jurisdiction. A famous trademark can reach across borders and into your category, even when you do not compete with its products or services. And finally, lesson number 3, in the United States, the dilution claim has its own standards and its own claim. To establish that claim, a dilution claim, a plaintiff must prove that its marks is famous and distinctive, that the defendant is making commercial use of the mark in commerce, that the defendant use began after the plaintiff mark became famous, and that the defendant's use is likely to cause dilution. Federal law recognizes 2 primary dilution claims: dilution by blurring and dilution by tarnishment. Dilution by blurring is an association arising from the similarity between a junior mark and a famous mark that impairs the distinctiveness of the famous mark. Dilution by tarnishment is an association arising from the similarity between the junior mark and the famous mark that harms the reputation of the famous mark. Imitating a federally protected famous mark can create liability for an infringement claim outside of the general trademark law. Don't let inspiration turn into infringement. Ownership is not about how hard you worked on your logo. It's about whether what you built can survive the legal landscape of federal trademark protection. This is why I'm the ownership attorney.